Close House Speaker Brian Bosma and Senate President Pro Tem David Long announce a fix for the RFRA to ensure it does not tolerate discrimination against any class of Hoosier, Thursday, April 2, 2015. Matt Kryger, IndyStarWASHINGTON, conservative Christian groups trying to overturn the fix to Indiana's Religious Freedom Restoration Act and 4 city anti-discrimination ordinances are asking the U.S. Supreme Court to weigh in on the case next year when it rules on a religious liberty challenge from Colorado. The Indiana Family Institute, Indiana Family Action and American Family Association of Indiana filed friend of the court brief in the Colorado case Thursday. The groups are urging the court to rule broadly enough to settle their own suit. Once again, government is using coercive force to crush and silence persons who disagree with its pressing agenda of the day, the groups wrote in their brief. In the Colorado case, a baker refused to create a wedding cake for a gay couple. The couple filed a civil rights complaint and lower courts have sided with them. The baker's appeal was heard by the court on Tuesday with a decision coming in 2018. The Indiana group's 2015 challenge to state and local laws is pending in Hamilton County Superior Court. The suit is an effort to bring back the original Religious Freedom Restoration Act, without the fix added by lawmakers that prevents the law from being used to discriminate against lesbian, gay, bisexual and transgender Hoosiers. The original law drew an uproar from business leaders, tourism officials and others demanding LGBT protections. The lawsuit also challenges ordinances in Indianapolis, Carmel, Bloomington and Columbus which ban discrimination based on sexual orientation or gender identity. The religious groups argue the city ordinances and the revised RFRA discriminate against conservative Christians who do not support same-sex relationships. The groups have said they have not expanded or offered certain programs in fear of violating the laws. By photo, Kurt Smith, president of the Indiana Family Institute, speaks to supporters of religious liberty legislation making its way through the Indiana General Assembly at a rally in the State House on Monday, Feb. 9, 2015, prior to a Senate Judiciary Committee hearing on the legislation. Photo, Charlie Nye, The Star. In their Supreme Court brief, the groups said they want to protect their right to promote their message without dilution by compelled inclusion of ideological opponents. That includes, for example, the American Family Association of Indiana limiting admissions to its grassroots training conference to those who share the ideals and values of our organization and its mission, just as pro-family groups like ours should not be compelled to include participants who undercut our pro-family message, so a cake artist should not be compelled to speak and associate with all the messages involved in a custom-designed cake to be used as a wedding cake in a same-sex marriage. Kurt Smith, president of the Indiana Family Institute, said in a statement. Compelling speech in either situation is forbidden by the First Amendment. Attorneys for the gay couple refused services by the Colorado baker argue the baker has no First Amendment protection because the state's anti-discrimination regulates behavior, not speech. Contact Maureen Gropp at mgropp@gannett.com. Follow her on Twitter, @BigGropp. A Hamilton County judge has allowed for a lawsuit to challenge the fix made to Indiana's controversial Religious Freedom Restoration Act. Nate Shute, IndyStar editor, share this story, http://indy.st/2xzoo